Law Officer Mark Nicholson. My name is Mark Nicholson. I'm here with my paralegal, Kate. And we're going to talk today about what happens if you are arrested. She is going to ask me a few questions that people commonly have when they are arrested, and I will do my best to answer her questions and then kind of fill in some gaps. And these are questions that people ask, me. They may ask her about, which obviously her being a paralegal, she can't give legal advice. And she has a very spotless record and has never been thrown in the slammer, so has no idea what it's like being arrested. So, with that, what kind of questions do you commonly hear when people ask about, you know, what's it like or what's the steps when someone gets arrested?
What's the first thing that happens after you're arrested?
Well, the first thing that happens if someone is arrested is they are usually taken to jail. They're fingerprinted, and they're searched by the police or the sheriff, depending on where they are, and then from there they have the opportunity to make a phone call. Obviously, I say call an attorney, call a loved one, and, but do not talk to the police. That's the number one thing. Exercise your constitutional right to remain silent and do not talk to the police. Um, Let me see. Now, do you have any questions in regards to after you're arrested in the court system?
Um, when will I know what I'm charged with?
Okay, usually what happens after you are charged with a crime within about 72 hours, depending on if it's a holiday. You will have an initial hearing or arraignment where the court will let you know what your charges are. um, Now it can be a little bit longer because if you get arrested on a Friday night and then Monday is a holiday or something like that, then obviously you won't get to court until Tuesday. Just like people that are arrested now on Friday, to today may be the first time they'll be in front of a judge who will then set bail. In some counties, they have a pretrial release system, so they will have the opportunity to see if they qualify for pretrial release. In Indiana, some counties have a pretrial release assessment, and this gives them the opportunity to look at if they're working, where they live, how long they lived, and then the court can allow them to be released on pretrial. And sometimes pretrial means they're totally released. Sometimes it means that they have to continue to make phone calls. Sometimes it means they may be on house arrest, depending on what kind of county, or GPS, especially if you're in Marion County. But that will be their first initial contact with the court, will usually be around 72 hours. They will have an opportunity to hear the nature of their charges and be given their rights about jury trial, about getting an attorney, about omnibus dates, and that's usually within 72 hours.
So, what happens after I post bail?
Okay, if you post bail, then at that point in time, um, your court will let you know your next court date. Obviously, you should have already had your next court date. If you're posting bail prior to your court date, because there's a pandemic, sometimes they are releasing people from custody, or they're just doing a summons where the person has to just show up to court. Then at that point, you'll get your next court date, and then make sure you come back your next court date. Don't get any new arrests. Um, don't uh, leave the state without getting court permission. Um, the main thing is making sure that you don't miss your court date, because you can be held in contempt. And also, if you um, get a new case, they can revoke your bail. The prosecutors can file a motion to revoke your bail, and then you will be back in jail again.
Okay. What happens at my next court date?
At your next court date, usually that's called a pretrial conference. Um, And at the pretrial conference, it's setting up what's the next court date. Is there going to be a plea agreement? Is if it's a misdemeanor, you may have a bench trial because those are set for bench trials. If it's a felony, it's a jury trial. So the pretrial conference is basically in state court is basically saying, hey, what is the next date? What is going to happen next in the case? And usually these are not very long in state court. Maybe you're going to usually wait longer in court than you are actually having court. So you may wait, 20 or 30 minutes, and then your hearing only lasts about 5 minutes because the judge is going to ask counselor, what is the next court date? What's going on in the case? And that's usually your next court date. And but now after that, you may have what's called a motion to suppress. If you're still in custody, it could be a motion to bail. If it's a murder case, it could be a motion to let bail. There's other motions that could be filed, motion to limine, motions for some kind of specific discovery that you're not getting. So there's other kind of hearings that can happen after you're released or while you're in custody. But normally what it's set up is the pretrial conference. And if you have a DUI, OVWI, operating vehicle while intoxicated, you can ask the court to give you a SDP, which is specialized driving privileges, and you can ask the court to do that. And you can have a hearing about getting a specialized driving privilege so you can continue to drive to work or school or pick up your children. And then you can also have a motion to challenge a refusal hearing if the if the prosecutor and the police officer say that you refuse to do a chemical test, a breath test, something like that. You basically refuse to comply with the police when it comes to doing this field sobriety test and, like I said, breath test and a chemical test, especially because there's a consent. And basically, by you driving on the roadway, you're consenting to take this chemical test. And if you refuse, your license could be suspended and all that. But the main thing is, if you want to challenge it, the way to challenge it would be through having a refusal hearing. So that's another kind of hearing that's specialized basically only for DUI and OVWI cases. You wouldn't have necessarily like a refusal hearing or specialized driving privileges if you're charged with a theft or a marijuana case or something like that.
Okay. If I go to trial, can you tell me about what trial is like?
Yeah, so before trial, there's a final pretrial conference, and during a final pretrial conference, that's when you are coming up with the final witness list that you're basically all the discovery, everything should have already been taken care of and ready for trial. Everything should be ready to go, and at that point in time, when you confirm with the court that you're ready to go to trial, prosecutor confirms, then depending on what county you're in, you may get a list of the jurors. So you can start going through the jurors. You may get that a week, 4 or 5 days in advance. In Marion County, in criminal cases, you get the potential jurors, like the morning of the trial, which is really, really challenging because you got about 15 to 20 minutes to pour through all these jury questionnaires. And at that point, when you actually have trial, one of the first things is going through the jury questionnaire. Then the jurors come in for what they call voir dire. The judge asks them questions and tells them a little bit about the process. Prosecutors and defense attorneys, then we get to ask them questions during the voir dire. And a lot of people think it's about picking jurors, when in actuality, it's not really picking jurors. It is deselecting jurors, because you're looking at who you think is not the best person to sit on this particular jury. and those are the people that you want to strike. You have a set number of strikes, and you're like, oh, this person may not understand our defense, so we're going to strike that and basically remove that person from the jury. And then what you're left with are the potential jurors. And normally what happens is the person that you don't like, the prosecutor likes, and the person you like, the prosecutor doesn't like. So they kind of start canceling each other out. So then, you're not able to say, hey, I like that person right there. I want that person to sit on the jury. You just don't strike that person. And then if the prosecutor doesn't like them, then they can strike them if they have the strikes.
Okay, can you tell me about the procedures of the actual trial, if it's a jury trial?
Yeah, so basically the procedure of a jury trial, like I said, it's, the voir dire where you're selecting the jury, and then from the voir dire, it's opening statement, and each party gets opening statement. Prosecutors go first, and then defense. Although the defense can waive giving opening statement, I do not suggest doing that. Then it's the questioning. The prosecutor starts off. They bring in their witnesses. Witness testifies, and then the defense gets to cross-examine that witness, and there can be redirect and recross. At some point, the prosecutor rests their case, and then once they rest, at that point, the defense gets to present their case, and the same thing. Defense does a direct examination. Prosecutor now is doing cross-examination, and there can be redirect, recross, until that's all done, and then the defense rests. The prosecutor at that point can do a rebuttal. Sometimes they do, sometimes they don't. And then after that, it's closing argument. And then the closing argument, the state goes first, then defense, and then the state gets to go again because they have to prove the case. But there's also a little known practice called surrebuttal, where you have the opportunity as a defense to ask for a surrebuttal because the prosecutors have brought up something in their closing or their rebuttal that you didn't talk about. So in other words, if you talk about points 1, 2, and 3 in your closing argument as a defense attorney, and in the prosecutor's rebuttal, they don't talk about 1, 2, and 3, they talk about 4 and 5. Well, technically, that's not a rebuttal because if they're rebutting what you're saying, they should only be talking about 1, 2, and 3. So at that point, you would say, Judge, I would like to you have a surrebuttal because the prosecutors brought up points 4 and 5, and in my closing, I did not talk about 4 and 5. So that's surrebuttal. A lot of judges don't usually grant those because I think they may not be familiar with the surrebuttal. Some defense attorneys and prosecutors are not even aware of surrebuttals. So I file a motion putting everyone on notice that if they do that, I'm going to ask for a surrebuttal. I do that at the final pretrial conference, so that way they know that this is something, and I quote the law that talks about surrebuttal, so everyone is on notice that if they bring up something that I didn't talk about, I'm going to request that surrebuttal.
Okay. What happened once someone is convicted of a crime?
Well, hopefully, if they're my client and we're representing them, the work that you do in the back and the work I'm doing in the front, they won't get convicted. But if they do get convicted, then depending on the nature of the case, it will determine what potential sentence they have. Obviously, if it's a major felony case, they're facing more time than if it's a misdemeanor. And on our website, we have a sentencing guideline, and it talks about all the range of sentencings from from murder all the way down to the lowest misdemeanor. So that is something that people can visit at marknicholsonlaw.com to see the different sentencing ranges. But at that time, usually the judge will then poll the jury and basically ask the jury if this is their verdict. Sometimes the individual parties, the prosecutor or defense attorney, can poll the jury, and then they usually have an opportunity for the parties to go back and talk to the jurors. Sometimes I do, sometimes I don't. I've done enough juries where every case is so different that I usually don't go back unless there's some reason, that maybe if I have a co-counsel or it's someone's first jury trial with me, like a paralegal may want to go back. It just depends. But I don't go back as like I used to in the very beginning. I always went back to talk to the jury and kind of listen to what their thinking is. About 30 days later, you have a right to be sentenced. Sometimes, if the person's out of custody, you may waive that right, or if there's a pre-sentence investigation that needs to happen, these are things that can extend the deadline and just say, hey, we need more time, or you may want to get sentenced within 30 days. But all the time that you're spending in jail, if you're in jail during this time, is counting towards your sentence. So it's not like you're losing any time, and whether you're doing 30 days in jail before your sentence or 40 days, all that time counts. And then once you're sentenced, at some point you'll be sent to the DOC if you're going to the DOC, or you'll remain at the jail, the DOC being the Department of Correction, or you will remain at the jail if you're been sentenced to the jail.
Okay. How does someone appeal their conviction?
And then appeal is they have 30 days to file an appeal. It's best when someone is convicted that they give a notice to the court. So during sentencing, once you're sentenced, the court is supposed to ask you, you have 30 to inform you of your right to appeal. In Indiana, there's a constitutional right to appeal in a criminal case. So the judge will advise you of your right, and then you can say, at this time, I would like to have an appeal, and then your attorney will file a notice of appeal to get the appeal process going, and it has to be filed within 30 days. From that appeal, it goes to the Indiana Court of Appeals. They make their ruling. If a party doesn't like it, they can ask for transfer to the Supreme Court. Then the Supreme Court makes its ruling. In certain cases, depending on the nature, the case could, go to the federal court if there's some kind of violation of a federal constitutional right. Often cases, if there's a long sentence, then they have what's called PCR, post-conviction relief. And that's something our office does where someone has exhausted their appeal to the Court of Appeals. They've exhausted the state Supreme Court, and now they're looking at post-conviction relief. And basically the things to look for in a post-conviction relief was there ineffective sense of counsel? That's kind of like the number one. Newly discovered evidence, or actual innocence. Those are mainly the three areas of post-conviction relief, with the number one being ineffective assistance of counsel.
Okay, thank you.
All right, thanks. And I will add that kind of like a little summary, when someone's arrested, that they go to the jail normally, and then from there they have their initial hearing, and from the initial hearing they have pretrial conferences, and then from pretrial conferences it gets into like a final pretrial conference, or before a final pretrial conference there can be motions for some kind of discovery hearing, motions to compel, motion to suppress, all these other kind of motions that come in between. And then you can have your final pretrial conference if it's going to trial. And obviously in the trial, and if someone's taking a plea agreement, the plea agreement would be before the trial. Someone can plead guilty with the prosecutor and come to an agreement. It's like a contract. Or the person can plead open to the court and let the court sentence them and say, Judge, I'm guilty. You sentence me to how you think is best, but this is what I'm requesting, that you have leniency and all that. And so that's basically the steps in the procedure when someone is arrested for a crime, a state crime in Indiana. All right.
Thank you.
You're very welcome. It was my pleasure. Take care, and good seeing you until next time. Bye.